introducing documents into evidence. So the reason why we're having these hearings is because it seemed to Jennifer and I that it would be better to have short status hearings to determine how long people need, instead of just giving whatever time they ask, while we're doing things by Zoom on COVID. And as you know, normally we set everything on at 9 o'clock. We take up agreements and short hearings, and then we work to the longer hearings. But we would definitely have more than 6.5 hours set on a docket. We would be double booked, so to speak, expecting that we could take things in shorter time than they announced, and there may be agreements and parties could talk. But on Zoom, if we either make you sit there all day long, have you start at 9 o'clock and you sit in the waiting room all day long, or we give you a specific time that we're going to do the hearing, and hopefully we've done everything else before your time. So with that said, it seemed better to give you a specific time rather than making you wait all the time, doing nothing, but being available in the waiting room. But it does mean that we can't overbook. And so finding out a little more about the case before we just give it, somebody may say, well, I normally can get a 2-hour hearing without anything else. I just want 2 hours. And that's what you would get. But we're trying to do it a little differently. Hopefully that we can respect your time better when we're in Zoom. So Ms. Anderson, you represent the original petitioner?
Actually, we're a counter petitioner.
Yeah, we're the petitioner, Your Honor.
Oh, okay. All right. So I guess on my docket, it looked, and I don't have access right now to the computer system because of outages, but I'm also at my home and not on the and not at the office.
That might be because I was asking for it to be set, and Jennifer may have thought I was the movement or something, which I haven't actually. Okay.
Either way, so Mr. McDaniel, what are the issues that you're seeking to resolve? And I'm more specifically than just divorce, child custody, child support, that sort of thing. Tell me
Yes.
what issues are.
Judge, in spite of Ms. Anderson and I talking a fair amount and trying to resolve the issues, we haven't seemed to resolve much of anything at this point. So we certainly have property issues. The main issue is there's a house. My client was hoping to keep it, but I believe we've decided and agreed that it needs to be sold at this point. The problem being,
who's living in it now?
My client is living in the house right now.
Okay.
The problem being that Mr. Young was ordered to pay the mortgage, which he failed to do throughout most of unfortunately, this case has been going on for more. And he failed to make most of the mortgage payments, certainly timely. Lately, he's been liquidating a lot of the property to pay the mortgage payments that he was ordered to pay out of his income. He had sufficient income to make the mortgage payments. So we're basically we're wanting an unequal distribution since he's liquidated his 401k, he's sold off the marital assets that had value to pay his obligation that he should have been paying. So that's the main property issues as far as I can tell. Again, we have custody issues. There's probably not going to be a lot of witnesses for that, but there will be a lot of documents, bank statements, that type of thing that have to be introduced. We have not resolved the custody issues. With regard to that, we'll need to probably subpoena.
How old are the children?
He's 13. He'll be 13 in 2 weeks, Your Honor.
He'll be 13. He's almost 13, yeah.
Okay, so on my docket, it says, okay, all right. I get it now. The child is a junior. And so, okay, I get it. All right, so one child. The way my document looked, I misread it to look like there were two children, but it's Justin Dwayne Young and in the interest of JDY Jr. So, okay, got it.
That's correct, Your Honor. Yeah, he's almost 13. We'll be subpoenaing probably a school counselor and a number of family and friends to report on the status and get you up to date on what's
Is he reporting a preference?
He is, Judge, and I filed a motion for you to talk to him.
Of course, we're
I
both
don't
hearing
need to ignore
different things on the
Mr.
preference. He seems to be preferring both parents.
Okay, well, either way, if he's stating a preference, I have to interview him. So then we'll get to the bottom of that. Are you asking to be present in the room or for me to interview him separately?
Your Honor, I don't have a strong preference. I'm not going to object if Mr. McDaniel wants to be in there, then I'll join in. If he's not insisting on it, I think the kid's very bright. I think he might feel more comfortable with just you and Jennifer, of course. But I don't have a strong opinion either way. I think really it depends on if Mr. McDaniel wants to be present.
Right. I prefer to do it with just Jennifer and me, but
I am fine with that, Your Honor.
okay.
But I was hoping maybe you might be able to do that possibly before the date of the trial.
Okay. We can do that. We're not going to schedule.
Judge, could you please meet with him in person?
Sure.
Okay.
Okay. We'll have to try to plan out how we do that socially distanced, but
Right.
We'll just sit far enough from each other. That's fine.
I know he would enjoy meeting you. I think it'll put him at some ease. Like any child, he's going to have some anxiety.
Okay. We won't schedule that today, but we'll schedule it. Once we schedule is the final hearing date scheduled? It's not, is it?
It's not. We're asking for a hearing.
Okay. So we schedule that, we will work backwards so that it is relatively near that time. But I'll be glad to do it in advance.
Okay. Thank you, Judge. Each of us has basically pending enforcement actions, Judge. I have literally a dozen or more incidents I need to discuss. Mr. Young, from our perspective, has not been following the standing order. He's not been following the temporary orders, and he has violated the temporary restraining order. So I have, like I said, probably 15 or more incidences that I'm going to need to go over with regard to the enforcements. Again, those are going to have this or two and some texts and other documents that need to be introduced.
Have you filed that yet?
It is filed. I am planning on amending the enforcement to include some recent violations.
Okay.
May I respond, Connor?
Yeah, first let me say is what you're asking for is joint managing conservatorship for your client and standard visitation. Is there any deviation from any of that?
Standard or extended standard, we're fine with either, Your Honor.
Okay. All right, Ms. Anderson.
Your Honor, Brian and I have been colleagues for a long time, and we've really made some effort. I had asked for a 4-hour hearing last fall, and rather than giving you a long explanation as to why I felt like we needed more time, I just really put a lot of effort into reaching out with Mr. McDaniel, Brian, and I disagree. I think we have made some progress. For example, it's huge progress that we are going to sell the place, the party's residence. We agreed to get an appraisal, and I think we're going to dispute. We're also asking for a disproportionate share, and we're asking for him to be reimbursed. Mr. McDaniel's mischaracterized it. I understand that we're both being zealous advocates, but he's mischaracterized what's really going on. What you're going to hear, he was late, Judge, on a lot of mortgage payments. But I know from experience with you, Judge, you never would have anticipated that husband would pay the mortgage for 18 months. So they made an agreement, and so he pays over $1,500 a month in child support, and he pays over $1,500 a month towards 2 different mortgages. And, you know, we made other attorneys, Brian and I substituted in, made those agreements, and it is a court order. But it's caused significant financial hardship, and that's what you're going to hear about Mr. Young. He has struggled. You know, you will hear that he was late, but he's also maintained it. It's not been foreclosed on. There were some. The order didn't include. You're going to hear about some other property that Mr. McDaniel referred to, and you will hear evidence about what's been going on with Mr. Young's attempt to preserve the property and Ms. Young's lack thereof. There were several large items like trailers and boats and a large, a very expensive car. Ms. Young, you'll hear, let that go back, which we complained about in a motion for enforcement. And then the bank is wanting to foreclose on all the other property that Mr. McDaniel's talking about. And Mr. Young, you'll hear, was try to get Ms. Young to help make payment. She refused. So he's only liquidated what he absolutely had to. He did sell a horse trailer. We did provide proof of that for the same amount both parties analyzed in the way of value. We can't get any help liquidating these pieces of property or these chattels from Mr. McDaniel and his client, and the bank is foreclosing. So it's actually better to sell than let the bank sell. And so we do have some urgency in that, Your Honor. But you know, we're going to be going back and forth about what the parties did or did not do. We've got complaints about mom not co-parenting, and we've got enforcement actions on the record. I think the main thing is that I don't think it will take that long. We know the house will be sold, and then the question is, are you gonna, you know, what are you gonna do with the proceeds? And I don't think it'll take so much voluminous records as just testimony from the parties about why, and we could stipulate. I think Mr. McDaniel and I could stipulate to figures. I think that'll help the court. Like, for example, Mr. McDaniel wants a disproportionate share. We want reimbursed for what Mr. Young has actually contributed to the mortgage for the last 18 months. But those are just mathematical factors. So I do think Mr. McDaniel and I can work together very effectively to help you with stipulations and agreements regarding exhibits, Your Honor, and maybe even spreadsheets.
We can certainly do exhibits, Judge, but the enforcements are going to take some time. I mean, this case basically originated because Mr. Young has a history of violence. He's violated the restraining order a number of times. He's made threats. He's, you know, endangered my client. The order specifically orders him not to sell property without a court order or consent of all the parties. We addressed that repeatedly. I told him, don't sell it until you let us know what's going on. We got no information. He sold the property, and afterwards they said, here's what we did. So it's going to take some time to go through this, Judge. I don't see, with the enforcements, I don't see it possible to do it in 2 hours. I mean,
okay, well, do you think that if I gave you 4 hours, you could do the enforcement and final hearing all together?
I do, Judge.
Kathleen?
Oh yeah, no problem. I think we can do it in 2, but
Let me ask you this. Okay. Well, one, you're on the right path with regard to the document. So I would like for you both to exchange the documents. That you don't have to say, I am introducing this in the trial, but any document you may seek to introduce into evidence that you'll exchange with the other side, and with a request for stipulation into evidence. That will save you time. It'll save you money getting it into proper form. A lot of times you're not disputing that this is a relevant document and it's authentic. You're just disputing what it means sometimes. And so if we can save a lot of time, we could introduce those in 2 minutes rather than 45 minutes periodically through the trial.
Do that, Judge. I don't think we'll have too much trouble on many
Okay.
of the documents.
All right, and then have them to Haley at least 2 business days before trial. And obviously, any document you have a legitimate issue as to its admissibility, you can certainly reserve that for trial. But so you should have to Haley your agreed stipulated documents, and then any other documents that you haven't agreed are admissible and but reserved. With regard to other stipulations, if you could make any other stipulations you'd like to have those to Haley at the same time as well. I'm not sure what date it is that we're going to give you, but at the conclusion of this, I'll let you go through the normal channel, just knowing that I'll give you 4 hours, and it will include final hearing and any motions for enforcement. And trying to think if there was anything else. Witness lists at the same time?
Yes, sir.
Okay. Oh, yes. That's what I was trying to think of. If we're going to, if y'all are now in agreement, now make sure you've talked to your clients again to make sure that is the agreement. But if you are in agreement to sell the house, I'm assuming it hasn't been listed yet.
It has not, Your Honor.
Okay, are y'all wanting to just go ahead and list it?
Yes, sir.
I guess there's a problem. I talked to my client just before the hearing, Your Honor, and apparently there's water running through the roof from the flood, from the weather in a number of rooms. So I don't know that it's going to be ready to list immediately.
Okay.
It sounds to be like an insurance claim, hopefully.
Yeah. Okay. I know that yesterday I spent all afternoon at Calvary Episcopal School mopping the floors and trying to stop leaks running through the roof, through the ceiling. There's, obviously sometimes there are pipes broken up there, but a lot of times, I guess what we found over there that we think is snow and ice had seeped through things, and found its way through and through the roof. And I guess maybe normally a roof wouldn't have failed, but it found ways through and then into the,
My client thinks it's probably a defective ridge vent that's allowing the snow and water to get in.
That sounds like what we're guessing happened at the school. So and I've heard of that at a number of places. So could very well be. Okay, then I won't say list it right now, but you may want to do the legwork first to say once it is ready to be listed, this is the person we'll list it with. And if you don't have an agreement, let me know, and I can, if you want me to, I can be the one that names the realtor. If you can't be, even if you aren't ready to list it today, you can have decided that you're going to list it and who you're going to list it with. Okay, anything further?
Your Honor, I feel like I have to just respond to something, so it's not, there's not a, if I don't want to leave something unsaid. There's allegations, Mr. McDaniel, I didn't want you to leave thinking, because I didn't respond, that it's the case. Mr. McDaniel claims that Mr. Young is engaged in family violence and put Ms. Young in danger and violated the order repeatedly. And I think really what you're going to find is, first of all, we have witnesses that there were allegations made and they were found to be unfounded. Police were called repeatedly, no arrests, no findings by CPS. Lots and lots of our evidence is going to show lots and lots of alcohol abuse and fights that would occur when Ms. Young would be intoxicated. And there's records of that with police and CPS. What,
Judge,
it's been 18
Mr.
months.
Mike, I can present evidence as well.
Daniel, I did not interrupt you. I purposely did not interrupt you. Judge, it's been 18 months. And what Ms. Young is doing is she made the allegations to try to gain an advantage, and she's still trying to do that. That's not water under the bridge. She refuses to co-parent. So him reaching out and trying to get information from her, the child's failing in school. Just so you know, Judge, Mr. Young has non-extended standard. That's what he agreed to, their JMC. And he's never been able to get a day over. She won't cooperate in anything. That's what the evidence is going to show. And she has the child, because it's non-extended standard, just every time there's any incident with school, and he's chronically failing. I don't know that we're going to need to call a lot of school officials, because I think the records will show that. But I just didn't want to say goodbye this morning and you to have that false impression. There are going to be allegations flying both ways, and Ms. Young has engaged in some violent behavior while intoxicated. She's had a gentleman living there, Judge, and there's a gentleman living there. And
Is there?
May I point out a few
for
things?
over a year, and my client's been paying over $3,000 a month and could never get any cooperation, including selling some of these items. So
Okay.
you will hear that going back and forth and back and forth and back and forth, but I didn't want to leave that by not responding.
May I point out a couple of issues as well, Your Honor?
Well, I'd rather.
My client tried to text Mr. Young about the house several hours ago, or maybe it was yesterday, I don't know, when the leaking started. He said, to find out who the builder was or who might be able to address it. He got a quick text back, sorry, your problem. Mr. Young, we talked about how we denied that she had a person living in the house. Mr. Young has managed to have a baby since the divorce started. So there's a little bit of, there will be a number of issues.
I wasn't talking about the morality of it. I was talking about the fact she's had a guy that could contribute to preserve the community property. He's made no effort, and she.
That's not true.
So
Okay, let me stop. This is, I know, and I probably need to do a little better job of shutting down all the factual talk, and just really getting into doing these status hearings. But it would, I guess I know that if I let one person start talking about facts, the other's going to have to, and then that's what we've got. So, but evidence will be whatever evidence will be. I'm not, I flush all of this out of my brain for the next hearing. So it's not going to be staying there and have a preconceived idea. I just want to be able to streamline this so that we can not only respect your time, but we can respect the time of all the other litigants who want to be in court. And so I think that's what we're doing. You can work with Jennifer to, because I don't know exactly when we're going to do it. We're going to have a mess once all the COVID stuff is lifted, with having to do a lot of CPS jury trials that are waiting in the wings that can't be tried now, and will have then deadlines. What we're going to do to try to manage that, I'm not sure, but it's possible that the next jury week for March, if we're not going to be able to do a jury, could actually take that time. So my question then is, are y'all complete in your discovery?
We just need to supplement, but I've been supplementing it regularly. We actually got Mr. McDaniel, after multiple requests, to supplement when he wouldn't do it. I finally got him to agree to a Rule 11 agreement.
But there's no discovery you need to take, no depositions or anything like that. You're right. Other than just answering some things if they change, you're right. Okay. All right.
Yeah, and Judge, one thing is, would it be possible to, I know you request the 48 hours, the 2 days before trial, to exchange information and get it to Haley. Could we have a deadline for Mr. McDaniel and I to exchange everything 4 days in advance, and then have 48 hours to go over everything?
I would think more than 4 days in advance.
Okay.
Okay.
4
Say
days
one-
and then 2 days before to the court, once we are able
One-
to stipulate.
1 week before.
1
um,
week, okay.
1 week before trial and 2 business days to have it to Haley.
Okay, and then we'll have two settings. One will be for you to speak with JD. That's his nickname is JD. And then 1 4-hour final hearing date subsequent to that.
Okay. So we'll get the final date scheduled and then we'll work backwards for
Okay,
interviewing the child.
Very good.
Okay, this will
Hear me?
conclude. our meeting. Thank
Can you
you.
hear me? Can y'all hear me?
Thank
Yeah,
you,
we
Ryan. Hey, Jennifer.
Can y'all hear me? So
Yes.
in March, we have March 11th and 12th, and then in April, we have April 12th and 13th.
for 4 hours, Jennifer, 11th and
Yes.
12th.
Those are our jury weeks in March and April.
Brian, I can do the 11th or 12th. Can you?
Of
I
March?
don't know. I don't have my calendar. I'll get back with you on Monday.
Okay, that's fine.
Of
Brian,
March,
we'll communicate with Jennifer.
March 11th or 12th, or what's the next one?
April 12th or 13th.
12th or 13th.
Okay.
And you guys need to talk about, we need to talk about when the judge and I can get together and interview the child prior to if it's going to be March or if it's going to be April.
Okay.
Brian and I can email you about that, Jennifer, after we settle on a final hearing date.
Okay.
Yep.
Thank
Okay.
you. Stay warm, everyone.
Thank you.
Okay.
Okay, bye.
Take care. Thank you, Judge.